Conference Series conference call. Today's conference is being recorded. At this time, I would like to turn the conference over to Jennifer Bartz. Please go ahead.
Thank you, Brendan. I would like to welcome everyone to the third session of our 2013 National Directors Institute Web Conference Series. We are in our 12th annual NDI season, a program which we started in 2002. As with our NDI programs in past years, we're looking forward to sharing the insights and experiences on corporate governance issues that we think matter most to you. The goals and objectives of our NDI program have always been to provide practical insights and useful takeaways to directors, executives, and board advisors. Materials for our previous NDI webinars and other sessions, including PowerPoint presentations and audio recordings, are available on our dedicated NDI website, which is foley.com/NDI. Information regarding our future NDI webinar sessions will be found on our NDI websites as well. We held our in-person 2012 NDI Executive Exchange in Chicago on November 14th. Please go to our NDI website to find many valuable program materials from that all-day program. Our next invitation-only in-person NDI Executive Exchange will be held on Wednesday, November 2013. Be on the lookout for information. And for the first time, Foley invites you to submit a nomination for our Director of the Year Award program. Awards will be given to a private and a public company director and will be announced during the NDI Executive Exchange. To obtain a nomination form, visit foley.com/NDI. I'd like to take the opportunity to thank all of our NDI co-sponsors, many of whom have been supportive to NDI for years, and some who are new to our program this year. AN Corporation, D.F. King & Company Incorporated, Eversheds LLP, KPMG, and Morgan Stanley, as well as our in-kind sponsors, Boardroom Bound and Inforum Board Access. Today's program is entitled Jobs Act Update, SEC Acts to Help Take the Private Out of Private Placements. With us today is Terry Nelson. Terry is a partner in Foley's Madison office. Mr. Nelson's primary practice includes hedge fund organization and operational compliance, other private fund offerings, broker-dealer and investment advisor registration and compliance issues, and litigation/enforcement matters involving state and federal securities laws and regulations. Also with us today is Chris Kane. Chris is a partner in Foley's Madison and Chicago offices. He represents private equity and strategic clients in mergers and acquisitions in a myriad of industries. He also represents high technology startups and is a co-founder of Catapult Chicago, a peer-sourced technology accelerator. Additionally, we have Peter Fetzer. Peter is a partner in Foley's Milwaukee office. His practice focuses primarily in the areas of securities regulation, mergers and acquisitions, corporate governance, and general corporate counseling to mutual funds, exchange-traded funds, publicly traded investment advisors, and public companies. Lastly, Patty Struck from the Wisconsin Department of Financial Services is with us today. Patty is the administrator for the Division of Securities. Patty's division manages registrations and notice filings for offerings. Additionally, the division registers broker-dealers, security agents, investment advisors, and investment advisor representatives, and monitors their activities through examinations. It also investigates complaints and, when violations are detected, initiates the appropriate administrative, injunctive, or criminal action. Patty is a frequent speaker on the subject of securities regulation as well as the prevention of financial fraud against older investors. Before beginning our discussion, I have a few housekeeping items. Today's program will last approximately 1 hour. The PowerPoint presentation will be available on our website at foley.com/NDI by early next week, or simply click the download a copy from the files box along the right side of the screen. If you experience problems with Adobe Connect, please call 888-569-3849 for technology assistance. For audio assistance, dial star, then 0 on your telephone to reach an operator. Today's program has been set up in both a discussion and an interactive question and answer format. We encourage you to submit written questions during the program. Type your question into the Q&A box at the right side of the presentation slides. We will respond to written questions at the end of the program, time permitting. If we do not have time for Q&A at the end of the program, we will be sure to follow up with you offline. To ensure you get the most out of today's presentation, we encourage all participants to maximize the PowerPoint to full screen usage. You can do so by clicking the full screen button located above the slides. As a reminder, today's program is being recorded and will be available on Foley's website by early next week. Foley will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please send an email to Jennifer Bartz at jbartz@foley.com. And please note, those seeking Kansas, New York, and/or New Jersey CLE credit are required to complete the attorney affirmation form. A 4-digit code will be announced during the presentation. Email the code to jbartz@foley.com to get a copy of the form, or simply click the download the form from the files box along the right side of your screen. Immediately fill it out and return it after the program. Also note that you must log on to both the audio and video to obtain CLE credit. Finally, it can take 6 to 8 weeks for us to obtain all CLE approvals, and we appreciate your patience. And now I will turn the presentation over to Terry Nelson from Foley and Lardner.
Good afternoon. On July 10th, the SEC approved amendments to Rule 506 of Regulation D under the Securities Act of 1933 to implement, among other things, the mandate under Title II of the Jumpstart Our Business Startups Act of 2012, or otherwise known as the Jobs Act. Title II mandated the SEC to lift the ban on general solicitation and advertising for our offerings conducted under the private placement exemption of Rule 506 if all the purchasers in the offering are accredited investors as defined under the regulation, and for offerings under Rule 144A under the Securities Act of 1933, provided the issuer has taken reasonable steps to verify that all such persons meet the accredited investor criteria for the new Rule 506C offerings and as qualified institutional buyers, or QIBs, under Rule 144 offerings, all at the time of the purchase. Also on July 10th, the SEC added the so-called bad actors disqualification to Rule 506 offerings, which means that offerings that include certain bad actors are precluded from using the Rule 506 exemption. The effective date of the amendments to Rule 506 and Rule 144A is 60 days from the date of publication of the rules in the Federal Register. Finally, on July 10th, the SEC voted to propose for public comment a rule that would serve to enhance the SEC's ability to monitor the private offerings under the revised Rule 506. Today we're not going to cover that proposed rule, but it is important reading for all of you, as most, if not all, of the proposals in the rule are likely to become law sometime this fall, and they will definitely impact on your use of a Rule 506C exemption. Before issuers and other sellers of securities proceed with offerings under the revised rules, it is important that such persons and their counsel understand the requirements in order to take proper advantage of the revised rules. Today, we're going to focus on the content of those revised rules and on best practices in order to help comply with those rules, discuss possible state securities actions with respect to the users of the revised rules, and also take the opportunity to provide a status report on the other securities registration exemptions impacted under the Jobs Act. Before we get started, and in order to provide some perspective about the current size and importance of the private placement market in the U.S., I want to first provide some statistics provided the SEC based on its review of Form D filings made with the SEC over the last 3-year period. First, Rule 506 offerings account for 99% of the capital raised under Reg D and represent approximately 94% of the total number of Reg D filings. Next, the significance of Rule 506 offerings is demonstrated by comparison to SEC registered offerings. In 2012, the estimated capital reported as being raised on Form D was $898 billion. That compares to $1.2 trillion raised in registered offerings. The amount for private placement offerings under Rule 506 does not even account for those private placement offerings where the issuers chose not to file the Form D. That number could be considerably higher. Of the amount of $898 billion, pooled investment funds reported raising $725 billion of that amount. The amount raised under Rule 506 in the future will no doubt, due to the changes voted on by the SEC on July 10th, surpass the amount of registered offerings with the SEC. Finally, for the purposes of our presentation today, we're going to use the terms general solicitation, general advertising a lot. What do they mean? Well, the regulations really don't define those terms, but the SEC has described general solicitation and general advertising to mean ads placed in newspapers and magazines, communications broadcast over TV and radio, and seminars where attendees have been invited by general solicitation or general advertising. The SEC has also thrown in the mix uses of publicly available media, such as unrestricted websites and other forms of social media. Now Chris Kane will cover the new Rule 506 exemption.
Thank you, Terry. Good afternoon. As Terry mentioned, Congress required, under the Jobs Act, required the SEC to lift the ban on general solicitation and advertising, not only for 506 offerings, but also in Rule 144A offerings. In the case of 506 offerings, they've created a new subsection C that permits the general solicitation and use of advertising, provided that the purchasers in the offering are all accredited, and importantly, the issuer has taken reasonable steps to verify that each purchaser was in fact accredited. And we'll talk in greater detail about what constitutes reasonable verification. And as to Rule 144A offerings, where the seller of the securities has taken reasonable steps to verify that the purchaser, or each purchaser rather, is a qualified institutional buyer. Now, keep in mind, the SEC took pains to note that the general rules under 506B now remain in effect, and so for those issuers that don't need to or don't want to take advantage of general solicitations and advertising and may perhaps want to be able to offer securities to up to 35 non-accrediteds, that exemption does remain in effect. As Terry noted at the outset, these rules go into place on or about September 9th of 2013, and on and after the date is when issuers can begin to take advantage of the lifting of the ban. Now, as Terry had mentioned at the outset, the key aspects are quote-unquote reasonable steps and quote-unquote verification of a purchaser's status as an accredited investor. And just by way of brief primer, from a natural person's perspective, an accredited investor can be measured either by income or net worth. And if it's net income, the investor has to have annual income in excess of $200,000 for the prior 2 years, with an expectation of having that amount as well for the current year. That goes to $300,000 if the investor is using the spouse's income as well. If you're relying on the net worth exemption, the person has to have a net worth of at least $1 million, or excuse me, in excess of $1 million, excluding the value of the person's principal residence. So with that in mind, the SEC received a lot of comments and requests that they provide at least some examples of methods that issuers could use to satisfy the verification requirement. And to that end, in the final rule, they did in fact include some examples of non-exclusive and non-mandatory methods that issuers may use. Now, at the outset, the SEC is careful to note that, as is the case with a lot of these tests, whether or not the criteria are satisfied is a contextual analysis taking into account the particular facts and the circumstances of each purchaser in the offering and the offering itself. And they take pains to note that because of the nature of this test, the more likely it appears that a purchaser is in fact accredited, then thereby the fewer steps that you as the issuer will have to take to demonstrate your reasonableness and your verification of their accredited status, and vice versa. The less it looks like someone is accredited, the more steps you'll have to take to determine or to establish reasonable verification. Now, among the factors the SEC said you should take into account as an issuer is really three things, and I think they're self-evident, but they lay them out. First is the nature of the purchaser and the type of accredited investor that the purchaser claims to be. The second one is the amount and type of information that you as the issuer have about the prospective purchaser. And last, and very importantly, you need to take into account the nature of the offering. And by that we mean the manner in which the purchaser was solicited, the terms of the offering, including any minimum investment amounts. And so to Terry's earlier point, if you look at one end of the spectrum, if you are making a general solicitation or advertising for an offering via a completely open website available to anyone, or pursuant to social media generally, or for example as a general email blast without regard to whom it's going to, the more steps you're going to have to take as the issuer to demonstrate the reasonable verification requirement. Likewise, on the opposite end of the spectrum, if you sent out an electronic solicitation to prospective purchasers that were culled from a database of pre-screened accredited investors, in that circumstance, the fewer steps you'll have to take to demonstrate you satisfied the reasonable verification requirement. Now, the SEC, getting to the examples or the non-exclusive methods that they have set out, the SEC did note that if you do use one or more of these methods, you will, as the issuer, be deemed to have satisfied the verification requirement under new Rule 506C, provided, however, there has to be substance over form, of course. You cannot rely on one of the verification requirements if it can be proven otherwise that you as the issuer or your agent in fact had knowledge that the purchaser was not accredited. So in terms of the non-exclusive, non-mandatory methods that they've set forth, the first one they address is if you want to rely on the annual income test, what would constitute reasonable verification is receiving and reviewing copies of any IRS form that purports to report income. For example, a W-2, a K-1, a Form 1099, and in addition to that, it has to be accompanied by a copy of the purchaser's filed Form 1040 for the past 2 years, and then secondly, it has to be accompanied by a written representation from the purchaser that they have a reasonable expectation of reaching that same income level, minimum income level, in the current year the investment will occur. And of course, just like with the accredited investor test generally, if that investor is relying on the income of a spouse as well, then he or she, as part of the written certification, also has to include the spouse's signature in that regard. If, as an issuer, you'd like to rely on the net worth criteria as a demonstration of accredited investor status, the SEC in the new rule makes clear that you can rely on certain statements as to assets and to liabilities, provided that the statements are dated within 3 months of being provided to you, and they are accompanied by a written statement again from the investor stating that all liabilities that they have that would be necessary to calculate net worth have been disclosed to the issuer. As it relates to demonstrating or satisfying the reasonable verification test as to the asset side of the balance sheet, the issuer can rely on bank statements, brokerage statements, other statements of security holdings, certificates of deposit, tax assessments, appraisal reports if they're issued by an independent third party. All would be deemed to be not exclusive but satisfactory in that regard. As it relates to the liability side of the balance sheet, the issuer can rely on a consumer report or a credit report from at least one of the nationwide consumer reporting agencies to demonstrate compliance with the liabilities. Third, the SEC has provided that an issuer can rely on a written confirmation from a registered broker-dealer, an SEC-registered investment advisor, an attorney, or a CPA, for example, provided that that person or entity has taken reasonable steps themselves or itself to verify that the purchaser is in fact accredited, and they've concluded that the purchaser is accredited. If you're going to rely on this written confirmation from a third party, again, that confirmation has to be done and dated within the prior 3 months at the outset to be able to rely on it. The SEC also notes that that list, as I mentioned, is not exclusive, and as the issuer, you can rely on any third party to fulfill that verification requirement, provided you, as the issuer, have, that's right, a reasonable basis, the word again, to rely on that person's verification. Next slide. Another couple aspects that the SEC addressed in this regard is what happens if you have a situation where you have an accredited investor who, prior to the effective date of 506C, had invested or had participated in an offering conducted by an issuer, and they'd like to do so in an offering subsequent to the rule in place. The SEC has said that's fine, and what you can do to satisfy the reasonable verification requirement in that regard is to obtain a written certificate from the person attesting to the fact that they are an accredited investor. And again, they took pains to note that this is only available for accredited investors that were accredited prior to the date of the effective date of Rule 506C. If they weren't accredited prior to that, you can't rely simply on that written certification. You'd have to go to the other methods that I just went through, or other methods, to satisfy the reasonable verification of their accredited investor status. Another big issue that was replete through the comments when and after the Jobs Act was passed is what would happen to an issuer, and more importantly to the issuer's offering, if it turns out after the offering concluded that one or more purchasers were in fact not accredited investors and the issuer had conducted general solicitations and advertising. The SEC notes in the final rule that provided the issuer can demonstrate that it did take reasonable steps to verify all purchasers were accredited and had a reasonable belief that they were accredited, that will suffice, in the offering, or the exemption for the offering will not be voided. You can still rely on it. But obviously, as a practical tip, it means, as you should always do, is to retain all of your records. So if something does happen in that regard, you're able to demonstrate both the reasonable steps and the reasonable belief as it relates to one or more purchasers that may turn out not to be accredited. Another issue that they addressed was the issue if you have a split offering, an offering that begins prior to the effective date of Rule 506C and perhaps concludes subsequent to that. The SEC has in the final rule indicated that in that circumstance, an issuer can choose to continue the offering after the effective date in accordance with the requirements of either 506B or C. So in other words, they would allow you to bifurcate the offering where perhaps you weren't doing general solicitations and advertising prior to the effective date. You may do so after the effective date, and they've made it clear that any general solicitation that occurs after the effective date would not affect the exempt status of the offers and sales that occurred prior to the effective date. So I think that was key that they did address both of those items, the potentiality of the busted exemption if someone turns out not to be accredited, and also transitional issues for offerings that straddle the effective date of the offering. Last couple issues that I wanted to address as it relates to the new 506C for the offerings. They are adding a separate box to Form D for issuers to check if you are in fact relying on the new 506C exemption. There is a box for the 506B as well. Obviously, the SEC will not allow issuers to check both boxes at the same time for the same offering. The SEC also addressed private funds, private equity funds, hedge funds, and to what extent they also would be allowed to engage in general solicitations and advertising as part of their fundraising efforts. There was a lot of commentary and concerns expressed about private funds engaging in general solicitations, and the SEC said from their perspective they absolutely are permitted to take advantage of the new 506C offering and maintain their exclusions from the definition of investment companies. They're mindful of the concerns, and they've promised in their commentary to monitor and study private fund advertising. They also took note to especially remind private funds of their obligations under security laws to comply with anti-fraud provisions with respect to misleading or making materially inaccurate statements to investors and prospective investors of a private fund. The last thing I'll note is the SEC also, for private funds and for issuers generally, to remind the community that all issuers of securities are, of course, still subject to the anti-fraud provisions under the federal and state securities laws with respect to the content of any public ads or notices.
Chris, just one thing to add on the private funds. In the proposed SEC rule that is now out for public comment, what is proposed for private funds is that they would be required to use certain legends and cautionary statements, and also to comply with the guidance under Rule 156 under the Securities Act, and that provides guidance on fraudulent or misleading sales literature that registered funds are now required to comply with.
Great, thank you, Terry. And now I'd like to turn it over to my partner, Peter Fetzer, who's going to talk about the new rules on bad actor disqualifications.
Thank you. So I get to talk about the provisions that I think most of us hope we don't have to deal with, the bad boy provisions or bad actor provisions. This was required by Section 926 of the Dodd-Frank Act. I will note up front, I think it's key to remember that it applies to all of the exemptions under Rule 506, so even if you're not doing a 506 offering that uses general solicitation, these are still going to apply. The other thing to note here is that as the SEC went and tried to put this together, they were instructed to rely on the bad boy provisions of Regulation A. In some cases, they've differed from that, and I'll try to highlight those as we go through them. But that was their starting point, and that's where they stuck with for the most part. The other thing I want to note before we go through in detail these bad boy provisions is that if you actually have to deal with one of these, you're going to have to parse through these very carefully. It's very difficult in sort of the abstract or hypothetical to really understand how they're all going to play out. So what I'm attempting to do here is to highlight some provisions that I think are key as a trigger potentially down the road. If something comes up, you might think, okay, that's something that's going to need to be addressed. So we'll turn first to covered persons under Rule 506D. And here, for my own purposes, I like to break it down into basically two categories. You've got the issuer, who's going to be a covered person, and you're also going to have a look-through to individuals or persons who control that issuer, who are going to be covered persons. Then you have, I'll just call them key actors in the offering. So think of your promoter or your private placement agent or any kind of paid solicitor. Those are key actors in the offering, and they're also going to be covered, and they also are going to have a look-through provision to see if there are people that control them that need to be covered. So if you run through the list here, some of these were not surprises. You knew they were going to be there. The issuer, any predecessor or affiliated issuer. The look-through applies, so you're going to look to any director, executive officer. And one change that was made by the SEC in the final rule relates to non-executive officers. You only have to worry about them if they're going to participate in the offering. So that was a change that the SEC made. Then you look to a general partner or managing member of an issuer. Again, these are sort of the control persons, people who are able to impact the management of the issuer, and they're going to be covered. Then you get to beneficial owners. Again, this was a change that was made by the SEC. If you look at Regulation A, it talks about 10%, and it talks about any class. The change in Rule 506 from Regulation A is that it only applies at the 20% level. It only applies to voting securities. So more narrowly tailored than what Regulation A has in its bad boy provisions. We then get into any promoter connected with the issuer in any capacity. I want to note there that the SEC made it very clear in the adopting release that they view that promoter definition as very broad, and that's their intent. And they also make it clear that you have to look through the promoter to any kind of controlling person. So you'd be looking at executive officers or any non-executive officers that participate in the offering. Then in an additional change the SEC made, the SEC proposed and they adopted that the covered persons will include any investment manager of an issuer that is a pooled investment fund. So think of an investment advisor to a private fund. They're going to be covered by this bad boy provision. They also made it clear that Regulation A talks about underwriters, because that's the terminology that's used there. They made it very clear that we're not dealing with just underwriters for the bad boy provisions for Rule 506. We're also dealing with anybody who gets paid to solicit. So think of a private placement agent or anyone else who's receiving compensation for going out and finding people to participate in the offering. And then I just note finally on this page that there are also the look-through provisions for the investment manager and for your paid solicitors. You have to look at their directors, you have to look at their general partners or managing members, and you have to look to executive officers and any other officer who is actually participating in the offering. So covered persons have been narrowed to some extent, but they're still fairly broad. And again, in my view, you want to look at the issuer. People controlling the issuer are going to be covered. Then you're going to look at key actors in the offering, private placement agents or paid solicitors, promoters, and you're also going to look through those to their directors, managing members, and executive officers. So going now to the disqualifiers that apply, one key thing to note here, and I think this was very favorable, the SEC did opt to say that the disqualifications that occur prior to the rule going into effect are not going to prevent you from doing a 506 offering. So pre-existing disqualifications don't prevent you from doing a 506 offering. They do result in disclosure, but they're not going to prevent you. So this is only going to apply after the rule goes into effect. So I'm just going to run through the provisions here and note some of the key things as I ran through them to keep in mind. So it applies to convictions of certain crimes. Those are crimes that relate to the sale of a security or that relate to a filing that was made with the SEC. A key thing to note here is that there's a look back, but there are two look backs. One look back applies to the issuer, and that's a 5-year look back. And the other look back is a 10-year look back that applies to all the other covered persons that we just ran through. So if you're not an issuer, it's a 10-year look back. If you are an issuer, it's a 5-year look back for crimes that relate to a sale of a security or a filing with the SEC. Next, we have certain court orders. Here I wanted to note a few things. Again, these are court orders that relate to the sale of a security or a filing with the SEC. Also, court orders that would relate to the conduct of an underwriter or a paid solicitor. There's a look back here. The look back is just a straight 5-year look back, and it relates only to permanent injunctions or restraining orders. Now, it's important to note that this provision says there's a look back for permanent injunctions or restraining orders, but you have to be aware of temporary or preliminary injunctions as well, because if you have a temporary or preliminary injunction or restraining order that's currently in effect, that is a disqualification. Now, the SEC looked at that. They're aware that some people wanted that to be narrowed, but ultimately the SEC said they were not going to narrow it. They're going to keep it as is, and if you want to try to get a waiver, you're welcome to, as the SEC said, to go in and try to get a waiver from them. The other thing I wanted to note here is that it does only apply to persons who are specifically named in the court order. So if you've got a preliminary injunction or a restraining order or a final one, it's only going to apply to people who are specifically named in that order. The next one is a final order of certain regulators. Here, I wanted to note a few things. First is that the SEC extended, there was a list that was provided by the Act. They added to that list the CFTC, so the Commodity Futures Trading Commission. So orders that come from the CFTC are covered by this. So if you get a bar or a final order from the CFTC, that's going to be a disqualification. It makes it clear in talking about these bars or orders from regulators that if the bar no longer is effective, that's not a disqualification. So an example would be sometimes a bar is provided that says it's indefinite, but after 3 years you can go and you can reapply to have it lifted, in essence. If after 3 years you're successful in doing that, you reapply, the bar no longer is in place, then it's no longer a disqualification. If you can't get that done, that doesn't happen, or you don't want to go back and reapply, you are able to seek a waiver in those circumstances from the SEC. I also want to highlight here that the look back for these type of orders is different. It's a 5-year look back, just a straight 5-year look back. So that would differ from an injunction or a restraining order where it could be possibly a 10-year look back if you're not an issuer. Then moving on to, there's a lot of SEC items that qualify. So you have certain SEC registration suspensions or revocations. You have cease and desist orders. For the cease and desist orders, that's a 5-year look back. The SEC looked at that. Some had argued that the cease and desist order should not be part of it, and their reasoning was, in essence, if the SEC has issued a cease or a desist order, it's been for the same type of bad acts that would have been subject to a court order, and so they didn't see any difference. So they are covered. And then we have stop orders that would apply to registration statements. Again, that's a 5-year look back. And then certain postal order violations would also trigger the disqualification. Moving next to when they would not apply. It's on the next slide here. Again, as I noted, pre-existing disqualifications are not going to prevent you from using 506. It's only disqualifications that are triggered after it goes effective. I also noted earlier that there's a waiver. The SEC has provided a little bit of gloss around the waiver process, but for the most part has left it open. They've made it clear that it's easier to get a waiver than it otherwise would have been, and they did that by providing delegated authority to the staff to provide waivers under Rule 506. If they had not provided that delegated authority, the waiver would have had to have been sought directly from the Commission and the Commissioners themselves. So that was a good step and a good move. It'll make it easier to get a waiver. The area that's going to be a bit ambiguous and going to be a bit muddled and is going to have to evolve over time is what kind of standards apply for having a waiver granted. And there the SEC specifically said they were not going to provide a list of standards and that they were just going to see how this played out over time. We do see as we read through the adopting release that the SEC has noted certain circumstances that would be likely to be ones where you could seek a waiver. So, for example, a change in control of the issuer, if that's occurred, that would be a likely reason to go in and say this waiver should be granted because there's been a change in control. The bad actors are no longer in charge of management of the company. A change in supervisory personnel is another one that was highlighted in the adopting release where you would likely be able to go in and argue for a waiver. Also, the SEC is sensitive to the fact that there might be ex parte orders that are brought against companies, which means there's not an opportunity for a hearing or a notice. And in those circumstances, again, if it's a temporary order, it's still going to be a disqualifying event. It's going to be a trigger, but they specifically said that that would be a circumstance where you could go in and seek a waiver. But we'll have to see over time what kind of standards are applied and how often and how quickly they're granted. But the SEC did at least make it easier by delegating the authority. The other thing to note here on this slide is just at the end, and we can actually go to the next slide, and that is that if the issuer establishes that it did not know and in an exercise of reasonable care could not have known that a disqualification existed, then that's not going to prevent you from doing an offering under Rule 506. Basically, think of it as a reasonable care standard. A couple things I wanted to note around the reasonable care standard. it's going to be a fact-driven analysis as to whether that applies. And here the SEC again indicated they can't really give a whole lot of detail at this point as to what steps should specifically be taken. So it's going to be up to issuers here to kind of lay out the groundwork and figure out what they need to do. In that regard, I note that this will be particularly challenging for issuers who are doing ongoing offerings. So think of a private fund who has an ongoing open offering, because the SEC did make it clear that you can't just do it at the outset and determine you don't have any bad actors and no disqualifications, but that you've got to on a, now they didn't tell you how often, they didn't say it was quarterly or semi-annually or annually, but on a regular basis you need to update and determine that you haven't had any bad actors come into the picture or any disqualifying events occur. So that will put some onus on the chief compliance officers of advisors to private funds to add that to part of their compliance program on how they're going to figure out how often they need to go back and double check that no disqualifying event has occurred. The other thing to note with the reasonable care standard is that there's no out because you didn't ask questions. In other words, the staff made it clear in the adopting release that if you have a reason to think that you should question the answers you're getting from a participant in the offering that's a covered person, that you need to ask questions. So you can't just turn a blind eye if you think that what the broker-dealer is telling you, you have reason to believe is not accurate. You're going to have to ask further questions and probe a little bit. That's it for the reasonable care standard. Turn now to the next slide. This is the provision that talks about the fact that pre-existing does not trigger a disqualification, but pre-existing does result in disclosure. Presumably, if you had these sort of events that had occurred even under existing law prior to these changes, you would have disclosed that. But now it's very clear that if you've had disqualifying events, you're going to have to make that disclosure. And again, I would just note this applies to all 506 offerings. So even if you're not using general solicitation, once this rule goes into effect, you'll need to make sure this disclosure is in your offering materials. There is also a reasonable care out here or exception. In other words, if you've exercised reasonable care and you weren't aware of these bad acts, these disqualifying events having occurred, you're okay still relying on 506. On the other hand, if you can't meet that exception, then failure to disclose these bad acts and these disqualifying events will result in an inability to rely on 506 for your offering. Going to the next slide, and this is the final slide, just note that in the changes to Form D, there will be a box that will have to be checked if you're relying on 506 that states that you're not disqualified from using the exemption. So with that said, I'll turn the time over to Patty Strook for the next portion.
Thanks, Peter. My job is to talk about the likely state securities regulator reaction to some of the changes that have been implemented over the past week and will be implemented over the next 60 days. The first question on the slide is, will state regulators target users of new Rule 506C who are taking advantage of general advertising and general solicitation? And in connection with that question, will state securities regulators review the reasonableness of verification processes utilized by issuers? And
Patty, we lost our slides, but just continue. We'll try to get them back on.
Okay. Even if the state regulators were inclined to target users, and it's a matter of opinion whether that's the case, I would say that it is not true. The verification process isn't the kind of information that we are currently in a position to extract from the information currently available to us, which is, of course, so limited to the Form D. But it is, that kind of concern is likely to arise in the enforcement context, where we, for example, review a complaint that we've received from an investor who bought in an offering under Rule 506C and who clearly doesn't qualify as an accredited investor. That is so often the case today, where an issuer will claim qualification under Reg D, Rule 506, and clearly they'll claim that the investors are accredited. They're not. And so if you'll note, I think in the materials you'll see copies of 2 comment letters by the North American Securities Administrators Association. Those do review some of the kinds of concerns that we have, specifically that fraudulent Reg D Rule 506 offerings, ever since NISMIA, have ranked as the most common product resulting in enforcement actions by state securities regulators. And private placements generally are among our annual list of top 10 investor traps. Because the regulatory and policy decisions that we are making today, both in terms of rulemaking and enforcement, are increasingly based on data and not on anecdote, we will be keeping records of investigations showing failure to verify reasonably. And I think it's interesting that if you look at the SEC release on the rule proposal, they talk about the mandate for the Commission staff to execute a so-called comprehensive work plan on the effectiveness of Rule 506C, and that work plan will include evaluating the range of purchaser verification practices used by issuers, assess whether the availability of Rule 506C has facilitated new capital formation or has shifted capital formation from registered offerings and unregistered 506C offerings to Rule 506C offerings. And finally, among other things, coordinate with state securities regulators on sharing information about Rule 506C offerings. And I think it's important to note a couple of things here, that the SEC has been, in an unprecedented way, since the enactment of the Jobs Act, open to dialogue with the states, and we have been meeting with the SEC through NASA to discuss the policy issues that we're facing, that they're facing, with regard to the relaxed standards under the Jobs Act. So it's fair to assume that we'll continue to collaborate. States were really pleased with the SEC's proposed rule, as the state regulators recommended, calling for the 15-day advance filing requirement of the Form D, along with the one-year disqualification for failure to file. And we were also pleased with the proposed revisions to the form itself, adding the website, the identification of control persons and beneficial owners, the addition of issuer size, eliminating the options of decline to disclose and not applicable, the addition of the admonition that finder's fees can trigger state and federal registration requirements, and of course that the rule implementing Dodd-Frank bad actor disqualifier will help address some of the problems that we have observed over time. The next question was, what about the use of portals that are not registered as brokers? Will there be enhanced scrutiny of their activities? And I think it's premature to talk about portals just generally, portals, platforms, intermediaries. I think that we're going to see a lot of activity in that area as the SEC moves toward clarifying that issue as it moves ahead with the crowdfunding rules. The next question was, will there be a grace period in which issuers will be advised by state regulators that the verification process utilized did not meet the reasonableness test? Here again, we're not the gatekeepers for Reg D Rule 506 offerings, and in fact, as I'm sure you know, we're preempted from requiring registration of offerings that comply with Reg D Rule 506. But we're not prohibited from investigating and bringing enforcement actions based on fraud, which has had the effect over the last close to 20 years of making states the primary regulator of Reg D Rule 506 offerings, because we're demonstrating that we are willing to exercise our anti-fraud authority. So when we become aware of inadequate verification processes, we will take those into account in deciding how to address the violations that we're finding. And then the final questions, the crowdfunding exemptions and state regulators' concerns. Here again, our concern is primarily fraud. And with the crowdfunding, the devil's really going to be in the details. Congress was so, without precedent, prescriptive in Title III of the Jobs Act that they really signaled to the SEC what the rules should say. So even though crowdfunding isn't available as a capital raising method right now, we know what the rules are going to say when they are eventually adopted. But one area that continues to remain a mystery is the intermediary funding portal piece. In most abusive securities offerings, the fraud arises in the way the sale is made. For example, when the investor hears from the person making the sale, whether the issuer is the person making the sale or there's a salesperson like an unregistered broker, a finder, and I think that's going to remain the concern in the crowdfunding context. If crowdfunding is really expected to help small businesses, the intermediary function is going to be critical, and it really needs to be done the right way. The SEC and state regulators have been under pressure for the last almost 10 years to address the issue of finders assisting issuers in marketing their securities, and a well-crafted response, I'm confident, will relieve that pressure. And of course, once again, we note that in the Jobs Act, the SEC was directed to consult with the states, and we have been very liberal with our commentary both to the SEC and in the media, and I'm confident that our concerns will be taken to heart. And then finally, the Reg A plus registration requirements under state securities laws, possible actions by regulators to make the process more streamlined. I can share with you that state regulators, as mandated under the Jobs Act, have been actively pursuing opportunities to work with the SEC corporation finance staff. And in fact, at least since April of this year, we've been working on that Reg A plus piece specifically. And we're looking for a solution that will help streamline the process for using Reg A, including producing a uniform regulatory approach for state review. That will, I think, be likely to feature a coordinated review component that will make offering across state lines a little bit easier for issuers.
Thank you, Patty. The final part of this, well, actually we have two more parts, time willing, but I think one of the most important parts is best practices for compliance under the rules 506C and 506D. Here are some thoughts that we have that we feel that would be useful best practices and some other helpful hints, if you will, with respect to the Rule 506C verification requirement. Would recommend that, if at all possible, issuers utilize the examples given by the SEC in the rule as to what are best verification procedures that would comply with the rule. Use those if at all practical. If not practical, whatever procedure you use, be prepared to defend that process was reasonable under the circumstances. And I think Chris gave you some great examples where different circumstances would result in a verification process that wouldn't be necessary to follow the SEC's lead, but could be something less. By all means, keep a written record of the verification process utilized. If you utilize third-party verification, maintain a record of the third party's written statement as to its verification process and determination. For the issuer, it's important to educate your personnel and others who may assist in the offering in what can be said in public disclosures. Implement a system where all advertising, general solicitation items are pre-approved by an appropriate person or by counsel. Provide in writing guidelines to all personnel on the procedures designed to prevent unlawful public statements. The FCC provided a couple of good examples or guidance on verification requirements, such that if the offering required a high minimum investment amount, oftentimes you'll see in private fund offerings where the minimum investment could be $100,000, $500,000, and so on. Certainly in those types of situations, the verification process probably isn't going to be very extreme, other than making sure that the purchaser's cash investment is not being financed by a third party. I think before you even go down the road of of needing to verify, obviously the issuer initial decision has to be, does the advantages of utilizing Rule 506C, in other words, public advertising, general solicitation, outweigh the costs of using general solicitation or advertising and making sure you have a reasonable verification process. That decision has to be made first. I can think of certain offerings that would not require 506C and instead rely on 506B, such as an offering solely to existing security holders. Any form of general solicitation or advertising is in fair use for an issuer relying on 506C. You could put an ad on a billboard, a newspaper, TV or radio, internet, social media, email, and so on. It is important to remember that, as Chris stated, all statements made in such public announcements are subject to the anti-fraud provisions under state and federal securities laws. And you should note, and I'm sure that Patty would agree, that securities regulators will be looking at the ads. And if they appear to be fraudulent or contain statements that are too good to be true, you can bet they're going to follow up. The FCC did point out that an issuer that solicits new investors through a website accessible to the general public, through a widely disseminated email or social media solicitation, or through a newspaper will likely be obligated to take greater measures to verify the accredited investor status than an issuer who merely solicits new investors from a database of pre-screened accredited investors created and maintained by a reasonably reliable third party. One thing to remember is that although you can use general solicitation and advertising under Rule 506C, the securities are still deemed to be restricted securities under the Securities Act. You still need to apply the specific legend to that effect and disclosure, of course, within your offering documents. I would avoid using projected performance numbers and other forward-looking statements in your ads. Such statements will attract attention, and they may come back to haunt the issuer. You should consider appropriate legends on the ads, and if the proposed rule by the SEC is finalized as proposed, it's going to require certain legends and cautionary statements on your advertising. But you should consider legends such as the securities may be purchased only by accredited investors. These securities are being sold upon reliance on an exemption from the registration requirements under federal and state security laws. Also, neither the SEC nor any state securities regulator has passed upon the merits of or given approval to these securities. Terms of the offering or the accuracy or completeness of any offering materials, and investing in securities involves risk, and investors should be able to bear the loss of their investment. Those are all necessary legends, and you should apply them. One thing to keep in mind when using Rule 506C is that there really is no turning back. Once you use general solicitation and advertising, unlike if you rely on 506B, you cannot fall back on the statutory exemption under Section 4.2. Also, if you rely on 506C, you may not be able to also rely on certain state limited offering securities registration exemptions, as they typically do not allow general solicitation or advertising. Certain CFTC exemptions for commodity pool offerings and commodity pool operators and commodity advisors do not allow public solicitation and advertising, so such persons will not be able to use Rule 506 exemption unless, of course, the SEC subsequently takes regulatory action to permit it. Certain investment advisors not registered under state security laws under an exemption from registration because they do not, among other things, represent themselves to the public as an investment advisor may be precluded from using the Rule 506 exemption.
Hey, Terry.
Yes.
Hi, it's Jennifer. I'd like to make the CLE announcement if now would be okay.
You bet.
Okay. Those seeking Kansas, New Jersey, or New York CLE credit are required to use the following 4-digit code to complete the attorney affirmation form. The code is HWAG. That's H as in Howard, W as in Walter, A as in Andrew, G as in George. To obtain a copy of the attorney affirmation form, download it from the Files box at the right-hand side of your screen or email Jennifer Bartz at jbartz@foley.com. Once again, the code for the attorney affirmation form is HWAG, H as in Howard, W as in Walter, A as in Andrew, G as in George. This code is only needed for those requesting CLE in Kansas, New Jersey, and/or New York. Thank you. Terry, back to you.
Okay, I want to cover just briefly some best practices under the Bad Act disqualifications under Rule 506D. The issuer should obtain a signed certificate from each covered person, including covenants and undertakings to report all such events during the course of the offering. Issuers are reminded that obtaining such certificates will take time and should allow sufficient time to get those before the commencement of the offering. Factual inquiries on intermediaries may be done by questionnaires, certifications, and background investigations, accompanied by contractual representations and covenants. Registered broker-dealers can be checked out by the issuer through the FINRA broker check. If a covered person turns out to be a bad actor in a Rule 506 offering that either was not disclosed to prospective investors, those would be events that occurred prior to the effectiveness of the rule, or for events that occurred subsequent to the effective date of Rule 506D, the issuer may still rely on the Rule 506 exemption if it can show that it did not know, and in the exercise of reasonable care, could not have known that a disqualification existed. That evidence of reasonable care is established by the issuer's factual inquiry based on the circumstances of the issuer and the other offering participants or covered persons. Again, it's important to keep a record of the factual inquiry. For an offering that is ongoing, that will continue for an extended period of time, I think as Peter indicated, there should be a system implemented by the issuer to require the covered persons to periodically execute a bad actor certificate. And that completes this part. The final part today is what's going on with the remaining initiatives, at least with respect to exemptions mandated under the Jobs Act. And I'm going to cover these very quickly. Patty touched upon a couple of them. Obviously, the crowdfunding exemption, still waiting for the SEC to come out with rules with respect to implementation of that exemption. Just as a recap, that it provides an offering of not more than $1 million during a 12-month period. Offering must be conducted through an SEC registered broker-dealer or funding portal. State securities registration requirements are preempted, but state securities regulators still have enforcement authority over such offerings. The bad actor disqualifications will apply. Those will be covered by separate rulemaking and not covered by Rule 506D. The SEC is expected to release proposed implementing rules sometime this year, with a probable effectiveness of the exemption probably early next year. Reg A Plus, we talked very briefly about that. That increases the offering cap from $5 million to $50 million. There are going to be certain additional requirements for issuers using Reg A Plus, including filing audited financial statements with the SEC. That offering, those type of offerings may utilize general solicitation and advertising, and importantly, there are no restrictions on the resale of those securities. Again, state securities registration requirements are preempted if offered and sold on a national securities exchange or offered and sold to through registered broker-dealers exclusively to QUIBs. It is likely that most offerings won't meet that criteria and will be required to register with state securities regulators. So that completes our presentation today. I believe we open for questions now.
We do have one question that came in. The question is for Patty, and it asks, why did the SEC exclude state-registered investment advisors from doing the third-party verification? And will NASA intervene to amend the rules so that a state-registered advisor can conduct this activity?
You know, I think that's a really good question, and I don't know the answer. But I think to the extent that parties are interested in adding state investment advisors to the list, that they should be commenting on that to the SEC, because the SEC, I think, has shown itself to be extremely accommodating and to be listening really hard for good suggestions that come in from the public or other interest groups. So ask them.
You know, also, Patty, in the release, the SEC said this is not an exclusive list. There could be other third parties, and I would think appropriately registered investment advisors would meet that.
We don't appear to have any other questions at this time. So I have one wrap-up statement to make. We hope you enjoyed today's presentation and ask that you please take 30 seconds to participate in our brief online survey at the conclusion of this call. These surveys are very helpful to us in ensuring that our NDI programs are providing you with practical advice and recommendations and developing ideas for future NDI topics. So thank you to all of our panelists today for excellent insights regarding the Jobs Act update, SEC acts to help take the private out of private placements. The contact information for the panelists is on the slide deck if you would like to contact one or more panelists. The PowerPoint recording will be available on our NDI website by early next week. Please mark your calendar for the upcoming sessions in the 2013 NDI Web Conference series. They're August 21st and December 4th. And don't forget to save the date for our NDI Executive Exchange on November 13th in Chicago, Illinois. And also, nominate a Director of the Year. For more information or to obtain a nomination form, visit foley.com/NDI Director Award, and those nominations are due by August 26th. Don't forget, those seeking Kansas, New York, and or New Jersey CLE credit are required to complete the attorney affirmation form and email it back to Jennifer Bartz at jbartz@foley.com after the program. And that concludes our presentation for the day.
And once again, ladies and gentlemen, that does conclude